names, and that's about it. So. All right, so as far as the wording of the Second Amendment goes, there's not a lot to it. When James Madison wrote the 12 amendments that would eventually become the Bill of Rights, I know there's only 10, 2 of them didn't make it. Attrition happens all the time. It's pretty straightforward. It says, well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. So you get a lot of commas in there. And commas do tend to turn all constitutional scholars into disgruntled English teachers because they can't quite decide the intent of the commas. And so early on, the intent of the Second Amendment really was kind of built around what Madison said about it. It was a compromise with the Anti-Federalists who were deeply paranoid about federal power. And so they wanted to ensure that the federal government would not be able to raise an army to use against the states without the states having the ability to defend themselves. So the militias are constitutionally enshrined. Today we call them National Guard. Each state has a National Guard system that answers to the governor. Most commonly we hear the National Guard called out by the governor in times of like civil unrest, times of natural disasters, because the states haven't gone to war with each other militarily in about 100 years. Hopefully we'll keep it that way. But, you know, the militia language in the Second Amendment was absolutely kind of what was at the forefront of James Madison's mind when he was writing the Second Amendment, as this kind of way to get the Anti-Federalists to calm down. You'll be able to defend yourselves. You can have your own militias with your own armories. And the language about individual possession was built around the idea that the armories that the militias had at the time of the founding were for heavy powder cannons, and uniforms. Most militiamen showed up with their own rifles. And so since everybody needed to have a rifle either for hunting or for defense if you were on the frontier, guaranteeing that individuals had a right to possess that rifle also guaranteed that your militia showed up armed when it was needed. And then all they had to do was collect the heavy armaments from the armories that were stationed around. I mean, even like the kind of slightly apocryphal Paul Revere's Midnight Ride, where he goes from town to town, from Lexington to Concord, warning everybody that the redcoats are coming. If he had shouted the British are coming, people would have shouted back, yep, been here for about 200 years. It would have been a very confusing thing to yell. So he had to let them know that it was the British regular troops that were coming, not British people in general, because they all thought they were. So, you know, they were going to raid the armory that contained the Continental Militia's cannons and gunpowder stockpiles and shot stockpiles. And so that's why they needed to rally the militia to go and defend it. And that was kind of the first official battle of the Revolutionary War. Nothing happens in the law around the Second Amendment really for about 120 years after that. It's not until Prohibition that Congress starts to kind of get into the game of regulating firearms, and they're definitely doing it with this militia-centered interpretation in mind. They passed what's called the National Firearms Act as a way to kind of help better regulate prohibition and crack down on organized crime, because organized crime used a lot of non-typical weaponry. During the Great Depression, you had kind of, like Bonnie and Clyde became famous for their use of a World War I automatic rifle as their common weapon. Clive fell in love with what was called a BAR, which stood for Browning Automatic Rifle. And so banning things from personal possession that wouldn't be considered standard issue in a militia is what the National Firearms Act did. And so 2 bootleggers were arrested, and they had in their possession a sawed-off shotgun. So they had a shotgun, and they cut the barrel off with a saw. It's a great name for a weapon. It really tells you everything you need to know about it. It's a shotgun, and they sawed it off to make it shorter so they could fit it in their coat like they were a pirate. And so they were charged, obviously, with being bootleggers in a time of Prohibition, but they were also charged with a firearms charge as a result of the National Firearms Act. And so they argued that their Second Amendment right to keep and bear arms was being infringed by the government by trying to prosecute them for possession of that shotgun. So the Supreme Court didn't buy it. The Supreme Court stuck with the militia interpretation of the Second Amendment and said no militia in its right mind is going to arm its infantry with sawed-off shotguns. So the state is perfectly within its rights to say a sawed-off shotgun is not standard issue in a militia, and so it can be regulated. And that was the interpretation of the Second Amendment that stuck around really for the remainder of the 20th century. So the first big change happens in 2008. So this is in your lifetime. I remember when this case happened, and everybody kind of read the writing on the wall. DC versus Heller dealt with a police officer from Washington, D.C. named Dick Heller, and he wanted to bring his service weapon home with him when he was off duty. The city of D.C. back in the 70s had passed a very restrictive handgun ban, so you were not allowed to possess handguns within the District of Columbia. And if you lived in the District of Columbia, you had to keep your personal weapons, rifles and shotguns, which were permitted, in your home, either disassembled or locked with a trigger lock or in a gun safe. And those are the only ways that you could keep those weapons. And so Dick Heller's case, he appealed to the city council and said, I'd like to get a special permit to bring my weapon home since I'm a police officer, and the city didn't grant him that, so he filed a lawsuit. It gets before the Supreme Court, and what makes this a really important case is the Supreme Court kind of communicates that they're willing to accept a broader interpretation of the Second Amendment. And instead of looking at those commas as linking clauses, that they're linking the concept of state militias directly to the right to individually possess, they're going to look at those commas separately. And part of their argument is basically like, we don't look at the First Amendment and see the 5 protections in the First Amendment as being interlinked. The freedom of religion exists regardless of if you want to publish a book about it. So we don't say, well, the First Amendment is a collective related group of rights where speech and religion and press and assembly and petition are all interconnected with each other, and you can't have one without the other. That's not how we read the First Amendment. We just spent like 3 weeks studying the First Amendment, and every time we talked about it, we basically said like press stands on its own, speech stands on its own, religion stands on its own. Each one is an individual right. So they're saying those commas were not linking connected clauses. They were just kind of delineating a list of rights that exist in the Second Amendment, and that they don't all have to be connected to each other. So they ruled that there is an individual right, and the government does have to make a compelling argument for restricting that individual right, just like they do with all of the other amendments. Now, this is where things are a little bit different. This case did not have any kind of broad, sweeping impact on federal law, and there's a reason for it. It happened in Washington, D.C. What's special about Washington, D.C.? It is the capital. Why is that special? What state is the capital in? It's not in a state. The Constitution specifically put the capital not in any of the states because they didn't want a state government that could like bear down on the federal government and put pressure on them. So DC's its own thing. It's the District of Columbia, and the city is Washington, and it's in that district. Congress is the government in the District of Columbia. Now, the modern Washington, D.C., Congress does not want to govern every single day. Like, that seems like a pretty big waste of time for all the reps and senators and the president to deal with, like, what's a parking ticket going to cost in Washington, D.C.? So they created a city government. There's a mayor in Washington, D.C. There's a city council. There's a Washington, D.C. police force that's separate from the Capitol grounds police force or the Secret Service at the White House. They have a civic government. They have elections to fill the spaces in that civic government. That's why the ruling in DC versus Heller didn't affect anywhere else. Because when the Supreme Court's interpreting how DC makes its laws and whether that law is constitutional, it only can affect places like Washington, D.C. And in our system, there is no place like Washington, D.C. But you'll see this happened in 2008. This was a big signal to gun right advocacy groups that the Supreme Court was willing to hear a different kind of argument over the Second Amendment and willing to rule on it. So just 2 years later, McDonald versus Chicago happens. McDonald versus Chicago dealt with a very similar case where you have a handgun ban in a major American city that was passed ostensibly to deal with, organized crime and criminal activity and a high murder rate. So the city of Chicago banned possession of handguns. Just having a handgun in D.C. was a crime, or not D.C., in Chicago was a crime. So now we know that the Supreme Court feels that that's too aggressive of a regulation, and that an outright ban on handguns is too aggressive. They've already said that in D.C. versus Heller. So this time the question in the case is, can you apply the Second Amendment using the 14th Amendment to all the other cities and states in the country? Just like they applied the Second Amendment, just like they applied the Sixth Amendment in Gideon versus Wainwright and said that all cities and states need to provide a lawyer, just like they said all school districts have to allow for student-free speech when it's non-disruptive in Tinker versus Des Moines. They're asking the court to use the 14th Amendment and say that that individual right that they said exists in D.C. versus Heller is applied to all the states. And so if you see the breakdown here, the justices all basically ruled the exact same way. It's only been 2 years. Nobody changed their mind. And so this is the case, McDonald versus Chicago, that actually did selectively incorporate the Second Amendment and apply it to all the states. Now, don't read into that states are no longer allowed to regulate firearms. That's not what the Supreme Court said. They said that this violated people's due process. There was an argument over whether it should be the Privileges and Immunities Clause of the Constitution that they use. When the Constitution was written, the framers thought of you as having dual citizenship. You're a citizen of the state you live in, and you're a citizen of the United States. And you can see over here on the board, I drew like two circles that kind of look like a fried egg. The idea of dual citizenship as an American citizen is that you might have special privileges and rights in your state, but those privileges and rights also need to include all the privileges and rights of your federal citizenship. So that's why it's a Venn diagram that looks like a fried egg, because all of your U.S. rights need to be included in your state rights. And so some of the justices on the court were arguing that they should use privileges and immunities as the language to incorporate it, but they opted for due process because when a state bans a specific type of weapon like a handgun, what they were doing was depriving you of due process for property. So they were saying to just blanket say you can't possess this weapon without any specific reason or any court processing having taken place is a violation of due process. But it also means that states can tell people you're not allowed to have a weapon. They all do. If you commit a felony, pretty much every state in the United States says you can't buy guns anymore because you've proven yourself, you've proven yourself untrustworthy, so we're not going to let you have a weapon anymore. So pretty much every state, if you commit a felony, one of the things that comes along with a felony title is that you won't be allowed to purchase firearms in the future. So those laws still stand up because due process is applied. States are also still allowed to require lots of requirements on the purchase of firearms through the interstate commerce power. So you can have to register a firearm. They can have waiting periods for the purchase on a firearm. All of those laws are still perfectly constitutional because they don't infringe on due process because the process is being applied that is fair and equitable to everybody. So that's why they opted for the due process language, because it still preserved a lot of the state power to regulate firearms in a reasonable way. They just said that these blanket bans of specific types of weapons was not reasonable, and that's why it was unconstitutional. So they did incorporate it, so it does apply the Second Amendment and that interpretation of it to all the states going forward. Any questions about that? All right, so that is it for today. I don't have anything else I need to cover with you. And next week, we'll just keep on moving.